Mark's going to moderate our next panel around tribal sovereignty, natives and the courts, native issues in the federal court system, and judiciary work happening here in the U.S. We're going to bring in Mary Kathryn Nagle, playwright, lawyer, mom, Cherokee matriarch, right? She was part of the original team that did the political insights for RNT. She's a current board member of Illuminative, and we're really looking forward to this conversation. So I'll get out of the way. Thanks, guys.
Okay. Welcome, MK. Good. I'm hearing you in my ear. I'm not sure I'm hearing. Are we hearing on stage? They can see a little tiny postage stamp, so if you have a letter, go ahead and, oh, there we go. There we go. While we're waiting, you know, before you get into your presentation, just a segue would be, we talked about pipeline and state legislatures and how people get to the Congress. It's the same for the courts. There is a pipeline, and one of the items that happened last election cycle that I think is really interesting is in Arizona, a number of women left the Arizona legislature to be justice of the peace. And it's a state office. It pays really well. It does a number of very important tasks. And it's also the beginning of that pipeline.
It absolutely is the very beginning of the pipeline, and that's why I always encourage any Nagle Law student to apply for clerks or federal judge. It's a fantastic experience no matter what you may ultimately do with your life, but it opens so many doors. Doors that you're not even thinking about when you're in your 20s, which is typically a Nagle Law student, but to have that experience and then see where you go later on in life. Usually, clerking for a federal judge is most often considered a prerequisite to becoming a federal judge. They're not always the case. There's always exceptions, but it's also really important for things that we'll get into in discussing this report. Just having that voice in the room when our sovereignty is discussed by those who work in the federal courts.
Great. I'll let you get into your slides.
Okay, great. So, hi everyone, good morning, good afternoon. My name is Mary Kathryn. I'm a citizen of the Cherokee Nation. Very proud and honored to be a board member at Illuminative, and thankful to Crystal and Michael and everyone at Illuminative for making this possible. I'm an attorney. I'm also a playwright and a screenwriter, but I'm really speaking to you today in my role as an attorney, and I appreciate the graces of everyone of letting me appear virtually. I have a 6-month-old baby, and it just gets a little impractical sometimes to fly her across the country all the time. And she's well taken care of at the moment, so hopefully she won't be making a cameo in this presentation, although she's definitely fought her way into other presentations I've made lately. So she may be making a cameo, but hopefully not.
Just real quick.
So I really appreciate everyone's graces in allowing me to do this virtually. You know, I think that when we think about this, tribal sovereignty, natives in the courts, you know, you will see I really focus on federal courts. And the reason for that is that because tribes are really, our relationship with the federal government is sovereign to sovereign. We predate the United States, we predate the US Constitution, but the US Constitution creates the framework for our relationship with the United States. Most of the issues that deal with contemporary tribal sovereignty or our rights as Native people are addressed in federal courts, not state courts. Now, there are exceptions to that. Of course, the Indian Child Welfare Act. That's a federal statute passed by Congress, but it ends up being adjudicated. The actual placement of our Indian children oftentimes ends up being adjudicated in state courts. So that's not to say that state courts are irrelevant or we don't need to think about who's a state court judge. You know, there are a few appellate state courts around this country that have Native justices or judges, and that's huge, and that should definitely be a goal that we have. But this report and the interviews I did are much more focused on the federal side. One is just a practical matter. I needed to narrow the focus somehow to actually be able to make some concise statements and conclusions, but also because that's just predominantly where our issues are litigated and dealt with. So I'll just sort of say that from the outset. And again, that's sort of what this methodology slide is about. But I interviewed more than 24 individuals, again, focusing on the federal court system. I interviewed Supreme Court law clerks, federal district court judges, federal appellate judges. If you're not familiar with the federal judiciary, a lot of people know about the U.S. Supreme Court, especially because it's been in the news a lot lately. But just below the federal Supreme Court, we have many appellate courts. And so those courts hear issues before it goes to the Supreme Court. The Supreme Court really only hears, it can vary year to year, but about 10% of the cases, may even be less now, that that the court is asked to hear. So a lot of cases just don't, the vast majority, right, 90% or above of cases where the litigant says, I want the Supreme Court to hear this, the Supreme Court rejects that because they just don't have time on their docket. And the Supreme Court tends to take cases where the court feels like it's an issue of national importance that hasn't already been decided by the court, or there's a circuit split between the circuits. And there are 11 circuits, 12 if you count the DC circuit, and they cover different geographic areas in the country. So where you all are sitting right now is in the Ninth Circuit. The Ninth Circuit has the most tribes out of any circuit because it includes California and Alaska, but also Arizona, Washington, Oregon. Other circuits that include a lot of tribes are also the 10th Circuit has quite a few tribes, as well as the 8th Circuit. Yeah, and the 4th Circuit now, I used to say, well, the 4th Circuit doesn't have that many tribes. Now, during the Trump presidency, there were several tribes in Virginia that became federally recognized, and so now the 4th Circuit also has some federally recognized tribes, as does the 1st and the 2nd. But really, the vast majority of Indian law cases that get decided by a federal appellate court are really coming through the 9th and 10th Circuits. The DC Circuit gets quite a few cases as well, simply because a lot of our cases end up being administrative law cases. So you're talking about, let's say, if you're suing the BIA or the DOI, the Department of the Interior, on a specific decision the Secretary has made, a lot of times those cases get filed in DC federal court because that's where the Secretary is. And so there's sort of venue and personal jurisdiction and all those other legal procedural issues are satisfied. And so those cases will trickle up to the DC Circuit. I also interviewed a lot of law clerks. Law clerks are usually recent graduates from law school who go to work for these judges. Law clerks have a huge impact on cases. Oftentimes, they are the ones to write the draft opinions. I clerked at the federal level, federal district court level in District Court of Nebraska after graduating from law school, and then I went and clerked on the 5th Circuit Court of Appeals. And as you probably know, there are federally recognized tribes in Texas, Louisiana, and Mississippi, which covers the 5th Circuit, which is the 5th Circuit. You know, I and my fellow clerks often wrote the rough drafts of the opinions that judges would then review and revise, but largely sign off on because we had talked about what the judge's decision was before the decision was written. So the point is just that law clerks have a huge impact on how cases get decided. The ultimate decision is made by the judges, but the law clerks are often the ones doing the legal research and writing. And so to have a native law clerk there, we'll get to that when we get to sort of the conclusions of the report, but it just, it's priceless, honestly. I did interview some state court judges. I interviewed a lot of individuals working in U.S. attorneys' offices as well as federal public defenders' offices. I interviewed several law professors to get their perspective on these issues. And I also interviewed practitioners who argue before the U.S. Supreme Court as well as other federal courts. And I had a set of questions that had been decided on by me and other folks at Illuminative to ask all of these individuals, but the conversations really centered around what is the perception of natives in the federal court system? How are we perceived? How are tribes perceived? And when we win, why do you think we win? And when you lose, why do you think we lose? And the overarching sort of frame, like my perspective of as a Native attorney coming into this is that, you know, up until very recently, in fact, when we wrote Reclaiming Native Truth, we were still living at a time where we were right on the cusp of this sort of landslide where now we are starting to win some really incredible victories in the Supreme Court. If you think about McGirt versus Oklahoma, if you think about Bradkeen versus Holland, right? These are huge, huge, huge victories. But when we were writing the Reclaiming Native Truth report just several years ago, back in 2017 and 2018, 2016, we were not winning these kinds of cases. We were losing them. You think about adoptive couple versus baby girl, which is a 2013 decision that came out of the U.S. Supreme Court, where the Supreme Court really rewrote the Indian Child Welfare Act statute. You had an issue that went up to the Supreme Court that was clearly a case of just statutory interpretation. It was about a specific section of ICWA. And the question was, were active efforts used to reunite this child with the child's biological father, who is a Cherokee Nation citizen, and also this child is eligible for citizenship in the Cherokee Nation, therefore ICWA applies. And the Supreme Court jumped through hoops to reach a decision where the Indian father, the Cherokee father, lost. And they wanted that Cherokee child to end up with the white adoptive couple who had been making all the rounds, who had been interviewed by Anderson Cooper and Dr. Phil, and you name it, and the whole country had tears in their eyes because of the tearful journey that this white adoptive couple was doing on the media circuit. And we lost that case big time in the Supreme Court. And there are several others that you can point to in the last 20 years, really, until we got to 2020, where we lost big time. And so we were really looking at how do we change this, right? How do we change from a situation where it doesn't matter what the law is, we just know tribes and natives are going to lose in the U.S. Supreme Court and in the federal courts just because the system is rigged against us, right? Oftentimes you would look at cases like adoptive couple versus baby girl, and you would know that the law was on our side. It was pretty plain. It was written as plain as it could be in the statute. And yet, there was this understanding that we would lose in the Supreme Court just because that was how the system was designed against us. We were trying to imagine how could that change? And that has changed. And I think, so part of coming at it, the research this time around is understanding what has changed, right? And how do we build on that momentum? How do we keep moving forward? Because we are under attack right now when it comes to the courts, let me tell you. And I think some of that attack is because we won in McGirt, and the governor of Oklahoma is pouring millions and millions of dollars into destroying tribal sovereignty. That is a very specific goal that Governor Stitt has. But also because I think that tribal sovereignty won the day, even though we ultimately lost and the pipeline got built at Standing Rock. Dakota Access, who was represented by Gibson Dunn at the time, really fought Standing Rock, Cheyenne River Sioux, Oglala, all the tribes who stood together, filed legal action, ultimately won in the court. But what happened with the movement, right, of indigenous people who showed up and our allies was that we delayed the building of that pipeline so much that it cost the oil and gas company billions of dollars. They did not like that. And they very much did not like the sort of narrative that was being spun, the pro-tribal sovereignty narrative of if it's a tribe's treaty territory, if they have treaty rights, if they have sacred sites. We know that there were, Native relatives buried there that the Dakota Access Company bulldozed through in 2016. But there was a very concerted effort after that of how do we undermine tribal sovereignty, because Gibson Dunn and its clients realized in that litigation with Standing Rock that that had huge dollar sign impacts for their oil and gas development opportunities. And so they have been very careful to design different kinds of litigation, whether it's Gibson Dunn representing white adoptive couples in the Brackeen versus Holland case, or in cases filed in where you all are in Washington right now attacking the Indian Gaming Regulatory Act as unconstitutional. They're going to keep finding ways to argue that federal Indian law, statutes passed by Congress that acknowledge our Indian tribes, using the word Indian, as entities that predate the U.S. Constitution, and our citizens as political citizens, because we are politically classified as citizens of tribal sovereignties that predate the United States before the 14th Amendment existed and after the 14th Amendment. The 14th Amendment does not change our political status, right? It had nothing to do with us, and in fact, we can get into that. But these are attacks that we're going to continue to face. So this research is critically important right now because we are being attacked on all fronts. So these are some of the lessons that I learned in talking to federal judges. And I just want to step back for a moment too and acknowledge that I spoke to people from across the political spectrum. So I actually interviewed judges appointed by President Trump. I interviewed judges appointed by President Biden. I interviewed judges appointed by Presidents George W. Bush, Clinton, trying to think how far back I went, but I mean, but you name it, Republican, Democrat, these were folks on both sides of the aisle, and we have friends on both sides of the aisle, right? We have judges who, I mean, look at what Justice Gorsuch wrote in McGirt, right? Justice Gorsuch is a Trump appointee, and I think that's something that's really important to remember, because I think sometimes too, when we want to approach this work as the activists that we are for tribal sovereignty, we tend to want to discredit anyone who got there from the Republican side, and I think that does us a disservice, because tribal sovereignty is not a Republican or a Democrat or a liberal or conservative issue. But one thing that was very clear in the interviews that I did is several of the judges who are sitting, especially sitting on some of these appellate courts, where they understand tribal sovereignty because maybe they have that personal relationship with a Native person or tribal leaders, or they've worked out in Indian country before, or they just understand it because they've worked on a bunch of Indian law cases. And they would say to me, when I try to explain these things to my colleagues, it's not that they're just jerks or that they're just someone taught them to be anti-tribal sovereignty. It's just hard for them to understand. Imagine you go through kindergarten through 5th grade or whenever you graduate to go off to middle school, and no one's ever told you that tribes are still here today, that they're legitimate sovereigns within the larger framework of the United States, and that they're just as legitimate in terms of how they're enshrined in the U.S. Constitution as the federal and state governments. We send our elementary school kids off to the state capital. Usually it's for a field trip at some point in their K through 12 education, as well as oftentimes to the federal capital. But if they're not learning about the tribal nations there, where their school is, and if those tribal nations have been displaced, then where those tribal nations are today, or the fact that tribes still exist, and the fact that the U.S. Constitution says they are legitimate sovereign entities, sovereign governments that govern with just as much right and authority as states and federal governments, how do you expect them to approach a case where all of a sudden a non-Indian litigant is saying it's not fair that I was driving across this reservation and I'm being accused of whatever crime, or you name the factual scenario that happens to come across, non-Indians do challenge tribal jurisdiction and tribal authority in many ways, in addition to the Gibson Dunns of the world, who are strategically looking for ways to challenge tribal jurisdiction and authority. We have just folks who, non-natives are all over our reservations and interacting with, maybe they're coming to our casinos, maybe they're contracting with us, maybe the Dollar General case, right, that happened in 2015, maybe they're opening up stores on our reservations. And unfortunately, there are situations where they challenge our jurisdiction. And if they're going in front of judges who no one ever told them in their K through 12 education that tribes are legit sovereigns, it can be really hard to do that educational work once they're on the bench. I know that having also spoken to Native judges who are currently serving as Article III federal judges, that's the educational work they're having to do. And thank goodness, right, we have Native judges on the bench today. We have very few, but thank goodness they're there. But that work should and can start when folks are in elementary school. And so this really intersects with sort of educational research as well. But imagine if you're a Supreme Court justice and the only true interaction you've ever had with tribes is when you dressed up as an Indian for Thanksgiving when you were in 4th grade in elementary school, right? That's not going to help when these cases of monumental importance, like Brackeen versus Holland, are before the Supreme Court. And the question is does Congress have the inherent authority to affirm the inherent right of tribes to adjudicate where their children are placed when their parents' rights to parent are terminated, right? So this becomes critically important. As I've mentioned several times already today, having natives on the bench makes a huge difference. These are 3 amazing Native women who President Biden has recently appointed. Judge Lauren King was appointed several years ago, very early on in President Biden's term. She is a citizen of the Muskogee Creek Nation. She's actually very close to where you all are right now. She is the first Native woman judge in the Western District of Washington. You could probably go drive by her chambers before you fly out of town. And so we're very proud and excited, especially those of us who are from Oklahoma and live and work in this area of Muskogee Creek Nation. I know I'm my husband is Muskogee Creek, and so I know people are very excited about her. Judge Sunshine Sykes is in the Central District of California, which is really kind of in many ways Southern California, but it gets to be called the Central District of California. And she is a citizen of the Navajo Nation and is just doing an incredible job. Again, a lot of these judges, 98% of the cases they get have nothing to do with tribes or Native people, but that 2 or 3% that they get, that does, and it can be higher, especially when we talk about the criminal docket, which we'll get to in a minute too. But the fact that she's there and other judges will come and ask questions, which makes sense when you think about it from this perspective. So the way one judge explained it to me, and I know this to be true from having clerked, every judge that comes to the bench was a practitioner or maybe an academic. Sometimes they come having been a law professor somewhere, and they had somewhere that they were an expertise in, right? So maybe a new judge is an expertise in employment law. Maybe a judge is an expertise in patent law. And so, let's say you're Judge Smith in the Central District of California and you get a patent law case and you've never worked on patent law. You didn't study it in law school, but you know that Judge Johnson is an expert in patent law. You're going to pick up the phone and call Judge Johnson and say, Judge Johnson, I got this patent law case. I've got this issue. Tell me your thoughts on patent law. Judges do that all the time. Imagine if there's no judge with any expertise or experience in federal Indian law and you get a case about whether or not the secretary was authorized to take land into trust for gaming for a tribe in California, right? What happens if there's literally no judges for you to talk to that any experience in federal Indian law? You're going to be at a deficit in deciding this case. Now, you'll have the briefs from the parties and you'll have your law clerks to do legal research. But basically, every other case that comes before the federal judges, right, there's someone on that court that studied that in law school and practiced that area of law before they got there. So making sure that we get Native judges, or even just people with federal Indian law experience, right, on the bench is so hugely critical to getting our cases fairly and rightfully adjudicated. Again, more recently, Judge Biden appointed Judge Sarah Hill here in the Northern District of Oklahoma. And I'm saying that I'm a citizen of the Cherokee Nation. She's Cherokee Nation. It's very exciting for Cherokee Nation to have one of our citizens as a federal district judge in the Northern District of Oklahoma, a district that has been incredibly busy ever since the McGirt decision came down, as there has been a lot of controversy from the governor of Oklahoma surrounding that decision, but also a lot of Natives who are now being prosecuted by the federal government because Oklahoma lost the argument that our reservations no longer exist. And so because of that, Oklahoma doesn't have criminal jurisdiction over a lot of the crimes allegedly committed by our tribal citizens on tribal lands. That is now a question for tribes and the federal government to prosecute. So these are there are even more federal judges, but these are some of 3 of the most recent appointees. In fact, just while we speak, Dana Jackson has been appointed by President Biden for the District of Montana. It remains unseen at this moment, just with the politics, that Holly might know more about the prospects of her actually getting confirmed, because that's a real political question at this moment. But she certainly has been appointed to the District of Montana by President Biden. And, I feel pretty confident saying that if President Biden wins re-election, we're going to see more Native appointees. And I could go on and on. I mean, Judge Humitiwa on the Ninth Circuit, she's a federal district judge within the Ninth Circuit, has done a lot. She started an Indian Relations Committee, and I've actually spoken to that committee before. They bring in Native practitioners to educate a committee of judges, and they have on that committee, they invite, federal probation officers, someone from the Federal Public Defender's Office, from the U.S. Attorney's Office, from all these different federal entities that interact with the federal courts, and they all come together several times a year, and they've been working on creating a curriculum about federal Indian law, like 101, that they're now going to share with everyone who works for any entity within the Ninth Circuit, whether that's at the district court or the federal appellate court there. And that is going to be such an incredible tool for every judge, every employee of the Ninth Circuit, to educate them on tribes, tribal issues, and the issues that come before the Ninth Circuit. So that wouldn't be happening if Judge Humitiwa was not at the Ninth Circuit, or she's a district judge within the Ninth Circuit. She now has a colleague in Judge Sykes And I think those two are now working together and collaborating in this effort. But it was really started by Judge Kamituwa. And so again, it just goes back to, if we're not there, we're not there, right? And up until now, we haven't been there, and we're starting to be there, which is very, very exciting. To be clear, Judge King and Judge Sykes are district judges within the Ninth Circuit, and Judge Sarah Hill is within the 10th Circuit, because Oklahoma is in the 10th Circuit. Very exciting. Another conclusion of my research is that federal Indian law must be taught and it must be mainstreamed. So what do I mean by that? Well, I think that, you know, let's talk about one thing, and that's federal Indian law as its own course. When we did the Reclaiming Native Truth report, very few law schools had any kind of Indian law curriculum or law course, except for if you went to like New Mexico Law School or ASU or AU or OU. There, you know, University of Colorado, there were some programs, MSU, right, Michigan State University. However, that has started to shift, and law schools are teaching federal Indian law. So now Yale Law School offers that course. NYU offers that course. Stanford offers that course. There's a lot of law schools that maybe don't have a full-blown Indian law program, but at least offer a federal Indian law course. And Mark, please feel free to jump in if I'm going too slow and I need to go faster, because I realize I talk a lot, and I know there's probably needs to be time for a Q&A. Do I need to go faster? Oh, okay. Well, anywho, I will just say one thing, and this is, I can't take full credit for this idea. This came during the interviews. I had an individual that I interview. I'm keeping everything confidential and not disclosing who said what. But one individual said, you know, we can't just be siloed anymore, right? We can't just be, because what then happens is those few schools that do have federal Indian law, it's usually the woke, progressive, liberal students who take it because they have a passion. I mean, you have Native students who take it, right? But then the non-Native students who take it are the woke, liberal students, and that's great. We want woke, liberal students taking Indian law, but we want everyone to take Indian law, right? We want the law clerks who go clerk for Justice Alito and Kavanaugh and Thomas to also have had some Indian law before they get to the Supreme Court, right? And if federal Indian law isn't mainstreamed, that won't happen. And what do I mean by that? Well, we have all these different courses in law school. So there's a federal courts course, right? There's a contracts course. There's a property course. There's, you name it, a constitutional law course. And our cases aren't taught within those courses. They're siloed off to the federal Indian law course. They could be in all of those curriculums. There are cases that could be worked into those curriculum. And that would be a very large project to undertake, but I think very worthwhile and very important. And I'm going to keep going because I think I'm going to be running low on time soon. It was very clear to me in doing these interviews that Indian gaming is critical to tribal sovereignty, but it is poorly perceived. What do I mean by that? Some of the folks that I interviewed who have been either practicing federal Indian law or on the federal bench since the 70s or the 80s remember the pre-IGRA days. They remember before Indian gaming became as widespread as it is now, and the very honest assessment was the quality of representation that tribes have in federal courts has gone up dramatically. So it's not surprising, right? Now that tribes have resources to hire attorneys, they're more well-resourced and more well-represented in federal courts, and they win more cases because they have attorneys that are well-trained and good at what they do, and we have natives who are attorneys, right? Native students can now afford to go to law school because either they can take out the loans and pay it back, or the tribes can fund their education, again, a lot in large part due to Indian gaming. However, there is a real negative perception of Indian gaming within the federal courts, and that has a lot less to do with federal courts and way more to do with Hollywood and entertainment and all of the other areas of research that will be discussed at this conference. But just to know that it does dramatically impact prejudice in the legal system, because there is a real prejudice against Indian gaming and a lack of understanding of how important it is and the good that it brings in all of our communities. And there's just, I think, an overestimate of the harm. I mean, I think all of us understand that gaming can be an addiction and there can be negative aspects to it, and that's certainly why a lot of tribes have really important programs in place to help individuals who may suffer with some sort of a gaming addiction or issue along those lines. but the actual positive things that gaming brings to our communities are not well understood. And that is a huge issue when it comes to perceptions of tribes in courts. And especially because appellate courts and federal district courts get a lot of Indian gaming cases. It was also brought up repeatedly that judges from west of the Mississippi tend to have a greater understanding of tribal sovereignty and federal Indian law. Now, that's not an accident either. If you look at this map, right, here's west of the Mississippi. I'm now realizing, and I created this PowerPoint, that the line is actually, the Mississippi is a little bit on the eastern side of Missouri. So we're missing a little bit of a sliver of what is technically west of the Mississippi. But the point is look at all the reservation lands west of the Mississippi. And again, knowing that the majority of tribes are in the Ninth Circuit, coming from like California and Alaska and other states, Montana, New Mexico, Arizona, right west of the Mississippi, Oklahoma has a lot of our tribes. And so therefore, the judges who are in these areas are going to have way more experience with federal Indian law than a judge from the Second Circuit or the 11th Circuit or the First Circuit. However, when you look at the makeup of the U.S. Supreme Court, Justice Gorsuch is an outlier, right? We don't get many judges that go up to the Supreme Court and become a justice from west of the Mississippi. And that's, again, because the legal institutions of the courts have been elitist historically, and there's been a bit of, sort of this narrative that if you're from Yale or Harvard and you're in the East Coast and working in New York or DC or Boston, that you're a smarter legal mind than if you're from Colorado, where Justice Gorsuch is from. And that's, a problematic narrative that's not true. And I think it does actually harm Indian country because, the judges that are from west of the Mississippi have more of a relationship with tribes because they see us, right? They see us more often in their courtrooms. I'm going to keep going. Federal Indian law jurisprudence and Supreme Court justice selection. This is a huge issue. And this is the truth right now. Our justices are not selected for the nation's highest court based on their federal Indian law experience. Now, part of that is just the reality that, yes, Indian law makes up a very small percentage of the Supreme Court's docket. That's true. We're not going to change that. And I don't think we're going to persuade anyone on the Judiciary Committee to make 50% of their questions related to federal Indian law, because we're just certainly 50% of the cases that go to the Supreme Court are not federal Indian law cases. But should we get at least one question? Absolutely. And we usually don't. I mean, for instance, here's, Justice Brown Jackson, who just recently had her most recent confirmation. She was not asked a single question about federal Indian law during her confirmation hearings. And that's true for a lot of the justices. And, that's something, and this would be interesting kind of to interface with Holly and her research on it, right? Because some of that goes to how do we interface with the Senate Judiciary Committee to get these questions asked. But, how do we communicate to the president, whether it's a Trump or a Biden or a Republican or Democrat, that when you pick your justices, they need to be picked on people who have a good track record with preserving tribal sovereignty, with preserving tribes' role in the U.S. Constitution as that third equal tri-sovereign with states and the federal government. That is critical, and we can't expect those outcomes of the Supreme Court if justices aren't picked on that basis. Justices know how they're being picked, right? And it's true, right? We're a very political country. Right now, Democratic justices are picked because of how they'll vote on abortion, and Republican justices are picked because of how they'll vote on abortion, right? So that's true. But all justices need to know that they're being picked by Republicans or Democrats because they're going to preserve tribal sovereignty and respect it. And we should be politically pushing for that in the halls of Congress and in the White House, right? And if we're not, then we can't expect those good outcomes at the Supreme Court level. So that's super, super important. I know we want to leave time for Q&A, so let me just keep going here.
Yes.
Federal judges are influenced by art, entertainment, and media. This is super important. They watch TV, they watch movies, they go to operas, they go to theater, they read newspapers, they watch Fox News, they listen to NPR. So we have got to get our stories in there. I don't think it's any mistake. For instance, if you listen to the Castro Huerta argument, so we won McGirt, huge victory. We get to Castro Huerta, and Chief Justice Roberts, Alito, and Kavanaugh are all saying the talking points that the Wall Street Journal put out, which basically says the sky is falling. criminals are running free. McGirt is causing a huge public safety crisis in Oklahoma. It's not true, but the Wall Street Journal published it. Why did they publish it? Well, because Governor Stitt paid millions of dollars to a PR firm to get the Wall Street Journal to publish that, and that's what happened. Now, Rebecca Nagle, my sister, also put out an article with Allison Herrera in The Atlantic that undermined all of that reporting and said, actually, here's the data, right? There aren't thousands of criminals running loose in Oklahoma. There are a small handful, maybe 5 or 6, that because of statute of limitations issues couldn't be re-prosecuted by the federal government. So it's true. But is this a gigantic public safety crisis that Oklahoma wants you to think it is? Certainly not. And you know who read that article was Justice Sotomayor. And she quoted it. And she actually spoke about it in the oral argument. And she asked Oklahoma's attorney about it. And she said, what about, I mean, you're spouting all this. What about what this, I read this article in The Atlantic that actually, where the reporters actually called every single district attorney's office and asked for the numbers. And the numbers don't match up with what the governor's saying. And the Oklahoma attorney could only say, well, I don't know about that, but you should read the Wall Street Journal. And the point is just that these justices they're impacted by stories in the media and that arts and entertainment. And we need to recognize that. And we need to have that in mind. I have as an example here that Justice Ginsburg did come see my play, Sovereignty at Arena Stage, and, you know, wrote me this lovely note afterwards. And, you know, I think it just goes to show that I think, okay, great. So I'm gonna keep going, 5 minutes till Q&A. That they really are impacted by this. I will say the other takeaway I had is that poor outcomes for tribal nations can result from erroneous factual assumptions. All of my interviews were anonymous, and I did that very purposefully so that judges would feel really comfortable talking to me and knowing I wasn't going to publish their name and what they said. I had several tell me things that were just not true. Things like, well, you know, I get concerned when tribes are trying to exercise jurisdiction over non-Indians because I know that non-Indians don't have attorneys in tribal court. Well, that's not true. And I as a lawyer can tell you why that's not true under federal law. And I also know as a practical matter of no factual scenario where that's happened, but that's the perception, okay? And so when we have these different misperceptions, they result in judges issuing decisions that are wrong on the law and harmful to tribal nations and tribal sovereignty. And so how do we got to start dealing with some of those misperceptions. Misperceptions about Indian gaming also factor into this. And so that is a huge, huge issue. And that, again, just ties into we've got to improve elementary and law school curricula as well. Perceptions of Native Americans are positive unless cases concern land use. So a lot of judges had a lot of sympathy in talking to me about poor Indians, and they felt really bad about Indians in poverty. What they didn't feel bad about is tribes trying to reclaim their lands. And that, again, I think it just goes back to some of this knee-jerk fear that we are going to have to learn to deal with and to address. And I don't have the solutions per se, but you know, just because a tribe is trying to save a sacred site doesn't mean they're coming back to take the entire state back, and that all the white people who now live in Alabama or California or Arizona are going to lose their homes, right? Like, that's not what's happening here. We've got to start to differentiate that, but there really was an animus of, like, we don't like it when tribes try to take their land back. And so that is something to unpack. And if you look at the cases where tribes, and look at what's happened with McGirt, right? Because that wasn't even a land back question. That was just, are the borders of the reservation still in place? Everyone who owns their land, all the non-Indians who own lands within the border of that reservation still own those lands. It didn't change any land ownership. But that was the narrative that the governor started to spin, and it's created all this fear and anxiety and negative media attention and problems, right? So this perception is something that we're going to continue to have to deal with. That's the end of my presentation for now, and I will stop sharing my screen. And Mark, I will turn to you, and happy to take some questions.
Great. I'll get it started. Thank you for that, Mary. I want to start with a broad question and then one that's a little more practical. The broad question is, we're at a point in history when the whole legitimacy of the court system is in the political discourse in a way that only happens about every 50 or 75 years. What does that mean to Indian law?
It's a really interesting question because, I was just the other day, or whatever morning, turned on the news and all the stuff about Justice Alito and his wife and the flag and Justice Thomas and right. I mean, there's a real, and then everyone's up in arms about, these different cases about, Trump's immunity and so there's from both sides a real attack on the court's legitimacy. And to your question, to tie it into history, it's interesting to think about the other times when some of the court's legitimacy has come into question. I'm thinking of like President Jackson's term, and of course we had this amazing victory in Worcester versus Georgia, and the Supreme Court upheld my nation's right to exist, said, Georgia, you have no right to even enter Cherokee Nation's lands, and the president refused to enforce that decision and then literally stacked the courts with justices who he knew would not abide Worcester versus Georgia and Chief Justice Marshall's decision. And, the court has, the court has come under attack politically over the years at different times in U.S. history, and the legitimacy of the court has been attacked. That is certainly happening now, and it's not happening because of any federal Indian law issue. We're sort of a bystander to that. But I think that in some ways, the irony is that I think the decision in Brackeen versus Holland, to me, stands as proof that the court is working, because there you had that was authored by Justice Amy Coney Barrett, who is a Trump appointee who, in many ways, I think everyone expected to vote against us, but she didn't. And that, I think, sort of undermines the narrative that the court is not legitimate in terms of its own disconnected political entity that isn't bending to the will of, the masses of what we're, it's sort of this just supposed to apply the law and not the pressures of what the majority, wants the law to be in that moment. And so, maybe what we'll see shake out is that what Justice Gorsuch and Justice Amy Coney Barrett are doing with some Indian law cases could maybe turn the tide in terms of the perceptions of the court. That's one possibility, but I do think the court has its work cut out for them in terms of preserving the overall legitimacy of the court. And you've got, President Biden and other Democrats toying around with the idea of Democrats trying to sack the court now. And I would just say I always have a knee-jerk reaction to that, because I just still have that desire to protect the court as an institution from either side ever doing that. But, it is, as you point out, a very interesting, if not challenging and stressful time for the court right now.
It's interesting, the American Academy of Arts and Sciences has recommended that the court move to 15-year terms with lifetime senior status after that. And that would be a non-constitutional change, but one that would make really profound changes, at least with the older justices.
It certainly would, and I think that, God, I think there's good and bad to that. And I think, there's a knee-jerk reaction from a lot of attorneys who have that sort of romanticized, like the court, there's a reason the court, the structure of the building is as beautiful as a Roman Catholic chapel, or whatever the right term. They're not places of worship, and yet they kind of are, right? You're supposed to have this reverence for the court as this institution up on the hill, right? You have to walk up the tallest steps in the country to get into this building. And so there's sort of this reverence for the court, and the fact that the justices go there for life and they become larger than life. But at the same time, I think that we're seeing that this, having folks serve these life terms doesn't necessarily serve our democracy, right? And so, but it could go both ways, because we never know who's going to be elected. And so, it's always interesting to me, the folks who take sides in this debate, because I'm going to be very honest, ultimately, I'm not sure whose side it ultimately serves to switch to that model. I don't know.
And then on the practical side, you mentioned the number of recent appointments, but if you look across the field at the number of Article III judges, we're so far behind that even with that, we're only at 0.5%. So to get up to any sort of parity would require a significant number of new appointments. When that happens and you can't get confirmation, how does that create a loop, I guess.
Well, that's the real problem, and that certainly has happened before. Other natives have been appointed. For instance, Arvo, a dear friend out here in the U.S. Attorney's Office in Oklahoma, the Western District, was appointed by President Obama, but couldn't get it confirmed. I hope, fingers crossed, prayers, good energy for Dana and her appointment. But a lot of these things have nothing to do with the qualifications of the individual. It's a real, and Holly could explain this better than I can, it becomes a real political process of what do the senators from that state think, what's happening with the Senate Judiciary Committee. Usually there's this sort of understanding that in an election year around this time, there's no more confirmations happening, because everyone's really focused on the election and we don't know who the next, and you're sort of, okay, the next president is going to get to start putting their people into the federal courts, and you sort of stop confirming. And so Dana Jackson's appointment is a little bit late in the game, and to be very honest, I think it's a little disappointing that President Biden didn't get more appointees in there, but I think that's a challenge that every president has, is getting enough appointees off and going. It's a lot of work to do that. So, I think that it can create that feedback. There's no feedback. There's no guarantee that someone who is appointed by a president will get that confirmation through the Senate Judiciary Committee and through the Senate because again, being appointed by the president's one step out of two. You got to be Senate confirmed, and that can be its own. And that's, again, why everything that Holly talked about, if we don't have a voice in the Senate, then the president can appoint all we want, but we're going nowhere, right? It's really critically important that we have that voice in the Senate.
It's funny, I remember when President Bill Clinton appointed Jeannie Whiting to the 10th Circuit, and that would have been huge, and she could never get confirmed. Let me ask about the other federal jobs with the courts. You think about everything from Social Security administrative law judges to there's just so many federal appointments in the judiciary that really we don't even think about.
Mm-hmm. Absolutely. I mean, one that comes to mind is U.S. Attorney. And so I know we need more Native U.S. attorneys. That's huge. But also, people don't think about this, federal public defender. So because of the way criminal law is structured in the United States, if you are a citizen of a tribal nation, an Indian under federal law, and you are accused of committing a crime on tribal lands, then because of 18 U.S.C. 1151, more often than not, except for some PL 280 exceptions, and we won't get into those complex situations now. We're going to keep it simple for purposes of this discussion. More often than not, you're under federal jurisdiction, federal criminal jurisdiction. So there are a large number of Native criminal defendants, indigenous criminal defendants going through the federal court system because of where their crime occurred and sort of the federal law that governs that, which means they're being prosecuted by the U.S. Attorney's Office and not the state. And that means that they're being defended by the Federal Public Defender's Office. And I interviewed several federal public defenders, as a part of this research. And they all said to me, Mary Kathryn, why, because they were all non-Native, they're like, why don't more Native law students come work in the Federal Public Defender's Office? We've found it very hard to recruit Natives. And I actually don't exactly know the answer to that. I'm hoping to reach out to some of the Native academics I know and just see if any of the Native law schools steer young Native law students in that direction. But what I've heard time and time again is just, there's so many Natives being charged in federal court and sentenced in federal court, and there's a lot of times cultural misunderstandings between them and the attorney who's representing them. How wonderful would it be if they could be represented by someone from their community, right? Because certainly the Federal Public Defender's Office tries to hire folks from the Black community, the Latinx community, the immigrant community, the Asian community, you name it. And they're sort of like, where are the Natives in the Federal Public Defender's Office? So yes, we need Natives every step of the way in every federal agency that exists.
One change since the Reclaiming Native Truth report 6 years ago has been the number of lawyers in leading institutions. And by that I mean either professors of law, deans of law school, or as for the last year, president of the American Bar Association. Maybe talk about that for a minute.
Well, that's hugely important, and you know, we've got more Native deans of law schools than ever before, and we, you know, you're referring to Mary Smith. You know, we have another Cherokee Nation citizen heading up the American Bar Association. That has a huge impact. The American Bar Association is the largest organization of attorneys in the United States. And to have a Native woman leading that organization, I mean, I would just say for instance, during Native American Heritage Month, like twice now, she has had an event where they screen one of my plays by Zoom for people to tune into and watch. And so you've got all these non-Native attorneys watching a Native play about a Native legal issue, and then hearing a talkback panel with Secretary Holland or whoever else on it, and thinking about Native legal issues that they otherwise would not have thought about. So when you have Natives at the helm of different institutions like that, then they can bring to the surface, raise issues, and educate non-Natives on Native legal issues that otherwise folks would never even think about or contemplate. And that's really huge. It really, really makes a huge difference. And I think the Native deans at law schools, we cannot underestimate the significance of that, because, you know, at the end of the day, that's where I think we've really need to focus some of our efforts. We've got to get more Native law clerks out there. And a lot of times the way you become a law clerk for a federal judge is you need that letter from the dean saying, this is one of the law school's top students. And, you know, if you're a Native dean, you're probably much more likely to cultivate your Native law students to go in that direction than if you're a non-Native dean who's maybe not thinking about that, right? And thinking about, our Native deans are probably going to think about the curriculum differently. And you're also very highly regarded. I will say, right after the Brackeen versus Holland decision came out, the Arizona Supreme Court asked me to come speak on a panel for every single Arizona State Court judge about Brackeen versus Holland. You know who they also asked to be on that panel was Stacey Leeds, because she was the dean of ASU Law School. They also invited the attorney for the Goldwater Institute, Tim Sandifer, who stood up and told everyone why Indian is an unconstitutional race-based term that should be stricken from any federal law. So don't get me started on that. But at least he was counteracted by Stacey Leeds and myself. And they went and they got the dean of the law school right there, right? Who happens to be a Cherokee woman. How powerful and amazing is that? So when we have Native people in these positions, especially in institutions of higher learning, like law schools, it is a huge game changer. And I think it's one that will be hard to directly measure. I mean, just in terms of raw data. But 30 years from now, 50 years from now, I think we'll be looking back and saying that was a turning point. That brought about change.
We're going to ask or open it for audience questions, but I wanted to ask one last thing. When you posted your letter from Ruth Bader Ginsburg, Mark the nerd immediately said, hey, there's a grammatical error in there. I love that. When you were clerking, you started writing plays. So maybe talk about that connection.
It was, I clerked in the District Court of Nebraska, and I convinced the judge I was clerking for to let me write and produce a play that we celebrated the 130th anniversary of a trial that took place in the courthouse where I was clerking 130 years later. And that trial was the trial of Chief Standing Bearer. And in 1879, he was arrested by the federal government, and he filed a habeas petition challenging his imprisonment, and the U.S. attorney at the time argued that Indians couldn't file a writ of habeas because Indians aren't persons under the law. And there was a whole trial about whether or not Indians could be persons under the law. And Chief Standing Bearer stood up and spoke at the end of the trial and made a very powerful speech, and he won. The judge decided in his favor, and it's a really important story about civil rights. And see, that case should be taught in all of our law schools, right? Because, I mean, what a powerful case about Native civil rights. Most people don't know about it, but it was really an incredible opportunity to celebrate that in the federal courthouse. We had 8 circuit judges who came, Larry Wright, who's now the executive director of NCI, was chairman of the Ponca tribe at the time. He came and spoke, and you had all these federal judges in the courtroom. It was a really incredible opportunity to connect contemporary federal judges to this powerful legacy of the court where they worked. And we were then invited to bring it to the Smithsonian Museum of the American Indian, and actually Justice Sotomayor came to that performance and spoke at that performance, and that was really powerful. And so, yeah, I love merging storytelling and the courts and our federal judiciary, and I think I hope to continue to do that. You know, I've had Justice Gorsuch came to one of my plays once, and you know, who knows? I'll just keep working on getting more of them out there. But I think we should all keep that in mind, that these are folks who go to the opera, they go to plays, they watch TV, movies, and so the work that we do as storytellers is also critically important in shaping law and policy.
It's a great setup for. Thank you. We have some questions.
Yeah.
Okay. Hi, everybody. My name is Juan. I want to teach you a little greeting that the Coahuiltecan people do. I'm going to say Amanam, and you respond with Yomanam. Amanam, and that means it is good, all is good. I'm Coahuiltecan, and I stand with the Miagan Garza Band in Central Texas, and I've been sent here by my elders, Dr. Mario Garza and Maria Rocha. Speaking to other people here throughout the last few days, I've seen that my concerns about repatriation are not only specific to our people in Texas, but for many in Indian country. And I speak for my people only because it's what I know and have experienced directly. And Mary, I believe I read that you have experience with NAGPRA, so maybe you can help. And I can only hope this conversation helps others as well. My understanding is that the more recent changes to the Native American Graves Protection and Repatriation Act has left Texas Indians abandoned in terms of repatriating our ancestors. And Texas faces a unique challenge for federal recognition due to our unique colonization history. The movement of the border and the utilization of Texas Rangers to slaughter indigenous peoples has left us in a tough spot today. And if anyone wants to talk more about that, I'm open to that. We've been told that we may have our ancestors returned if we can have federally recognized tribes join us, but this has not been successful for whatever reasons, and sometimes we're just given a no and we're not sure why. Private institutions we're requesting remains from then dangle these no's we've received in our faces as justification for denying us remains, but our understanding is that this is not what's written into the law. It's still an option for private institutions to say yes or no. We're primarily in conflict with UT Austin, who houses thousands of ancestral remains in cardboard boxes. Years ago, we received a letter from the university president with promises to have remains returned, a promise that has not been kept, and in fact has been completely ignored and argued against time and time again. One quick story I have to give an idea of the frustrating encounters we have with UT Austin. They allowed a few of our community members to pray over remains, but we were given rules on how to handle them. We weren't allowed to touch boxes, allowed to stand too close, and couldn't verify that remains were actually in there, all because they weren't sure, they couldn't trust us with ancestral remains. And the courts aren't all that helpful either. And I know we all have our own concerns, but I'm here today to raise awareness of this repatriation challenge Texas Indians face. So please keep us in your prayers, because we feel underrepresented, alone, and helpless to help our ancestors who can't continue their journey into the great mystery because they're collecting dust on a cold shelf in a cardboard box. So please go on Instagram, follow us at Return the Remains, and help spread our message. To make this question more applicable to all of us, I don't want to take too much time away from all of us, but why is the judicial system making it so hard to gain justice, especially for non-federally recognized tribes? And if there's any advice you have on our specific case of repatriation, I'd appreciate any words you have to share. Amanam.
Thank you. Thank you so much for those comments, and I very much appreciate that. I will say, one, NAGPRA is an important statute. It has some real problems and pitfalls. And so what just happened was not an amendment to the statute, but new regulations. And so those were newly issued, but it hasn't changed some of the problems inherent in the statute. For instance, I worked on multiple NAGPRA cases. I still work on NAGPRA cases. I worked on with Sac and Fox Nation trying to repatriate Jim Thorpe. And his nation and his children wanted to bring him home, and the Fourth Circuit Court of Appeals said NAGPRA didn't require him to come home, and I don't want to get too far into the weeds on that. NAGPRA has some real pitfalls. You're right that NAGPRA, the way it's written, does not acknowledge the rights of state-recognized tribes the same way it does federally recognized tribes. However, one thing I would encourage you to look at, and again, I don't want to be giving legal advice here, so this is just very general, so tell your attorney to look at, since I don't technically represent you here on this panel, but I will say, look at the lineal descendant and look at the way it's defined in the regulations, because it wasn't the best written statute in the world, but the way that the lineal descendant language is defined in the regulations, I think it's very clear that what Congress intended was for the descendants to be defined in an indigenous way with traditional knowledge and cultural understandings of how we relate to one another, which isn't Billy Bob gave birth to Susie Thornton Johnson, who gave birth to Fred, who gave birth to, or however, you don't have to come up with all your paperwork and say, oh, here's all the birth and death records that if we're from the same ceremonial grounds, or there's sort of traditional forms of indigenous kinship that we have and understand that I think is upheld by the statute and the regulations. So I just encourage you to look at that, because that might be helpful, and you might want to look there. So Mark, I think we probably have time for one more question.
Okay, we have time for one more virtual question.
Yes, this question is from Noma, who's joining us virtually. I'm going to law school in the fall to fight the Bighorn case in Wyoming. If the challenge is with a red state, like many of our issues are, where do you recommend we work as natives in the legal arena to be most effective?
This is a great question, and I will say thank you for this question. I would encourage you to look on both sides of the political aisle and to think about, this is sort of a multi-pronged approach for everything. There's the courts, there's the halls of Congress, and there's also the media and PR, right? And these all play together. And to work with tribal leadership, because oftentimes our tribal leaders, they have relationships on both sides of the hill by necessity, because they have to work with both sides to get VAWA passed, or to get these important pieces of legislation that restore tribal sovereignty. And so if there's an issue of protecting a sacred site, or you name it, where it may seem like you're going to have a hard time in a quote-unquote red state, you don't know what kinds of relationships your tribal leadership may have with that congressional delegation from your state. And there may be an opportunity to partner with them and to work with them, and maybe not. I mean, look, I'm from a tribe in Oklahoma. There are times when our leadership has great relations with the Oklahoma congressional delegation on certain issues, and then sometimes we're at odds, right? And so sometimes we have to engage in a media campaign, and that's where knowing how to work with the media and to get that narrative out there of what are you fighting for, right? What are you fighting to protect? How do you tell your story? How do you get it out there? And that can really start to galvanize decision makers too. I like to think of federal courts as last resorts. I don't think we want to be going into the federal courts to start a movement or to win a major victory. One, it takes forever to get a case through the federal court. It just does. And it's sort of, it's just a hard place to win. So I think, other things, I don't want to discourage people from filing a lawsuit when it's necessary, but look at what happened in Standing Rock, right? The tribes ultimately won, but it was years down the road after the pipeline was already up and running. So federal courts are really kind of places of last resort for these important fights that we're fighting.
Mary Kathryn, thank you so much.
Thank you.
Great to see you.
Good to see you all. Thank you.